You're listening to a Kumaran podcast.
Hi, I'm Kumaran Thavarajah. I'm an English lawyer and partner at Kumaran's corporate M&A and finance teams.
And I'm Lachlan Salt. I'm a senior legal consultant, an Australian lawyer, where I started my career at Ashurst in Melbourne and have been in Denmark now for 6 years at Kumaran.
And on this podcast, we're going to talk to you about the distinction between representations and warranties. So, Lachlan, maybe you can tell us a little bit about it. I mean, representations and warranties, to me, they seem to always go together. Does that mean that they're the same thing?
No, they're not the same. They're often referred to in the same breath or thought of as going naturally hand in hand. And perhaps some people think of them as a drafting technique that lawyers like to use where they say the same thing twice. But that's not the case, and certainly they're not interchangeable terms for the same legal concept. You're most likely to see them in a sale and purchase contract context, and that's the focus that we'll have today. But they're also in lots of other types of contracts. But essentially, warranties are contractual statements of facts which give a buyer certainty about facts or matters that it cares about, and also a right to sue for damages if it turns out not to be true. Representations, on the other hand, they reflect pre-contractual statements, that is, statements that were made before the parties entered into the contract that might have induced a buyer to buy, for example.
Okay, interesting. So that's quite a key distinction, I guess, here that we've had, because you say that representations are pre-contractual.
Yep.
To a tort law claim.
Yes.
Well, you have a tort law claim for misrepresentation, and warranties and a breach of warranty claim is a contract law claim.
Exactly.
But then why do I write the word representation in my contract if it's a tort law claim?
Well, you're right that this distinction between warranties come from the world of contract law and representations come from the world of tort law is correct. And that's one important thing to bear in mind. We include representations in a contract to reflect the fact that we have had these pre-contractual discussions. Certain statements have been made in the lead up to entering into the written contract. And so therefore we want to memorialize those statements in the written contract. So just because they're in the contract still means that doesn't mean that they're any less of a tort.
Okay, interesting. So this is where I think we have our first key distinction is that it is, in fact, it sounds like it's good for a buyer in a sale and purchase context to have the benefit of what we call warranties, contractual statements,
yep,
as well as calling them representations, because then it's saying, you can bring a contract law claim and you can bring a tort law claim. And how do you feel as a seller? I guess you're opening yourself up to two types of liability there, aren't you?
Yeah, so as a buyer, you want to maintain as many possible avenues as possible to make a claim, whether that is in contract or in tort. Now, as a seller, obviously you want to shut down or you want to limit as many possible avenues. And of course, you're entering into a contract, so you'd like to keep any claims against you in the world of contract. So you'll be looking to exclude where, for example, in the relevant section, the seller represents and warrants. You just want to only say the seller warrants and try and exclude representations there.
So we say here, so you're opening yourself up to two grounds of liability, right? But what does it actually matter? Because I'm sure there's some kind of, no double jeopardy. You can't be sued for the same breach twice. So what about the amount of damages that can be claimed?
Sure.
Is it the same?
No, not necessarily, because depending on whether you are bringing a contract claim or a tort claim, so for warranty or representation, the damages potentially will be calculated differently depending on the circumstances. So the remedies are different depending on whether it's tort or contract. So we can get into what the differences are between a contract claim for damages or a tort claim for damages.
So, and a good way to think about this, I think, is for a breach of contract law claim, the quantum of damages is to put the non-defaulting party into the position they would have been in had the warranty been true. So you get the benefit of the bargain you made, right?
Yep.
So here the buyer would, it would be what is the amount of damages that would put them in the position they would have been in had the statement been correct. Now, for a tort law claim, you're being put into the position you would have been in had the had the contract not been entered into.
Had the tort never been committed.
Exactly.
Right.
Yeah.
Yep.
So you're being put into your starting position.
Yeah. You sort of put back into your original position, as you say, the tort, they try to, restore you, essentially.
Is there a more concrete way we can think about this?
Sure. Let's take the concrete example where, for example, we are buying a painting from a seller who says that this is a Hammershøi, a genuine Hammershøi, and he says it's worth 2 million kroner. These are not real numbers. We're not our experts here, but let's just go with this.
So I buy the painting for 2 million.
Yep.
Yeah.
And it turns out that it's not a Hammershøi, and in fact, a Hammershøi is only worth 1 million.
Right.
This particular
painting,
one.
was only 1 million. Okay, so I've overpaid.
You've overpaid for what you thought was a Hammershøi.
So it actually isn't a Hammershøi even. So the warranty, this representation and warranty he gave me, we'll say he gave both, was incorrect. And so now because it's, essentially a fake, it's worth 1,000 kroner.
Right.
So I guess the question is, if there was a representation and warranty that there was a Hammershøi, if there was a breach of representation, I'd have a tort law claim, right? And my tort law claim is very intuitive. It just says, what would be the position I'd be in if the transaction was never entered into? If the tort was not committed? Well, I'd have my money back. How much would I have back?
Well, 2 million minus 1,000.
Yeah. So
you've got a 1,000 kroner painting.
Sure.
You've got that.
I've got that, yeah. So I roughly get back my 2 million. So it's nice for me to have the misrepresentation claim. Whereas what about if I had only got a contractual warranty? There was no representation.
Right. So contract law's not going to be your friend here because they're going to hold you to the deal that you made.
Yeah.
You made a deal for what you thought was a Hammershøi and was warranted to be a Hammershøi, but actually a Hammershøi is only worth 1 million. So you don't get your full 2 million back. You only get up to the 1 million that you bargained for.
So there it is. There's the key difference, right? Because contract law is not going to rescue you from making a bad deal. It's just going to get you the benefit of the deal that you made. So here, I actually made a bad deal, but it wasn't a deal for a fake painting. I made a deal for a Hammershøi. That's what you warranted to me.
Yep.
But the court is going to say the market value of this painting becomes a valuation issue is only 1 million. It's not worth the 2 million you paid for it. Therefore, I only get 1 million less than 1,000 back. Exactly.
So contract law is not going to help you out if you've made a bad deal.
Yeah.
And therefore, misrepresentation, a claim under tort, if you're a buyer, will help you even if you've made a bad deal.
So really the key point, sellers need to ensure they're just giving warranties. How can I be certain? Is there a way I can draft my contract to be certain that no representations are given? Is there, what about this entire agreement clause we see?
Yeah, so often entire agreement clauses will exclude any prior statements or representations that have been made that are not reflected in the contract in writing.
Yeah.
So that's where an entire agreement clause as a seller you will want to sort of try and limit your exposure there.
Okay, well, that's great. I think that gives us a good starting point for understanding the distinction under English law between representations and warranties. So to summarize, in 3 key points, I'd say representations are pre-contractual and they give rise to a tort law claim. Warranties are contractual. They give rise to a breach of contract claim. And a key distinction there is a tort law claim, the misrepresentation claim, can actually rescue me from making a bad deal, whereas a contract law claim can actually get me the benefit where I made a good deal. And the example we gave, it was rescuing me from a bad deal. But you could come up with another example easy enough where you'd want the benefit of the deal you made if it was a good deal. Yep. And then the contract law claim would get you out. And then finally, I guess, this point around a seller ensuring that they carve out representations and ensuring that claims are only brought in the contract for breach of warranty by ensuring the entire agreement clause is drafted well.
Yep.
Perfect. Well, thanks a lot for listening, and we hope you listen into our next one.
You have been listening to a Kumaran Rømert podcast. The podcast reflects our legal specialist view of the current state of the law. Please be advised that the state of the law is always subject to change as new case law emerges.